Good evening, everyone. Thank you for joining us this evening for Parent University. I want to thank you from the very bottom of my heart for just taking a little bit of time to listen and receive some great information this evening. I also want to introduce our interpreter for this evening, Ms. Teresa Ordonez. She's the RISD Translation and Interpretation Liaison. So thank you, Teresa. At this time, I want to introduce to you guys our very own Kara Heyman, who is the RISD, I think, Transition Services Coordinator. So I'm going to turn this over to her so that she can not only tell us a little bit about the department that she works and also introduce our guest speaker for this evening. So, Kara?
Hi, I'm Kara Heyman, and I'm the Transition Coordinator for Richardson ISD, and I welcome you tonight in a coordinated effort to bring our families information that can be used to access information and services for family members or students that we have in the district. So Transition Services really provides information to families that may have a student or a family member that receives special education services that needs some additional information about agencies and connections in the community that can help support them in many different areas. And tonight we're super excited to partner with Tressie Weeks from the Weeks Law Firm, and she has been a huge supporter of families in Richardson ISD and helping them navigate some very specific challenges with having a student or a family member with special needs. And so Tressie's going to present tonight on guardianship and alternatives to guardianship for families that need that information. And in a couple of weeks, she's coming back to talk to us about another really important topic about how to best utilize your SSI funds and some of the options that are available. So I'm super excited. Again, Tressie's been a huge supporter of Richardson ISD, and I turn over to her to talk to you about guardianship and alternatives to guardianship tonight. Thank you, Tressie.
Thank you, Kara. It's so good to see everyone. So I'm going to try to share my screen and let me know if this works, because I have a PowerPoint I'm going to share with you today. Okay, so Kara, is this working? Are you seeing the progression of slides?
Yes.
Okay, great.
Perfect.
Thank you. And Kara, I appreciate everything you do for the special needs community in the Richardson ISD. So just a little bit about me and my firm. I've been a resident of Richardson for 21 years, I guess it is. But I have a law firm in Plano, and our law firm serves families with kids with disabilities. And that's the heart of our law firm, is to help families. And so we help families plan for the future of their child. We do special needs trusts, wills for the parents, that type of thing. And then we also do guardianship and alternatives to guardianship. And so tonight, as Kara said, we're going to talk about guardianship and alternatives. Our next presentation is going to be about ABLE accounts and maximizing your child's SSI check. We may do a presentation on special needs trusts at some point as well. So tonight we're going to talk about a lot of things. We're going to talk about what is guardianship, the different types of guardianship, the 8 steps to obtaining a guardianship. We'll talk about the duties and powers of a guardian. How do you change a guardianship? And then we're going to talk about less restrictive alternatives. And you're going to hear that phrase several times tonight. We're going to talk about what that is. We'll also talk about supported decision-making agreements. So lastly, we're going to talk about whether guardianship is appropriate for your particular family. So what is guardianship? So when your child is under 18, as the parent, you can handle their money. You handle their medical care, take them to the doctor, you communicate with the doctors, obtain, their medications, health insurance. You make decisions about their school. You make decisions on where they live. You provide food and shelter for them. You decide the treatment and the services that they want. But the moment that your child turns 18, you lose those rights, essentially. The law gives your child, who is now an adult, the right to make their own decisions. Your child's going to make their own decisions about whether they go to school, where they live, their medical treatment. They'll handle their own financial matters. They have the legal right to sign contracts. They can sign leases. They can even get credit cards and charge things online. And in some cases, they might be taken advantage of. So what if your child is turning 18 and they are not able to make decisions that they need to care for themselves? What if they have a disability that does not allow them to make those decisions? What if your child cannot manage their own finances? What if they can't handle their own medical care? What if they need assistance making decisions, evaluating options, and communicating their decisions? In some cases, they might need somebody to make a decision for them. So guardianship is a legal process. This is a process we go through the court. You do have to have an attorney in Texas for guardianship. And just to let you know, I'm talking about Texas guardianship today. Guardianship law is different in every state. So we're just talking about Texas. So in Texas, a guardianship, there are two main people. The person who needs the help is called the ward. The person who is giving the help is called the guardian. And in this legal proceeding, the court decides if somebody's not able to manage their own personal and financial affairs. If the court determines that they can't manage those things, then the court is going to appoint a guardian. But a guardianship takes away the legal rights of that person, that ward. The guardian makes decisions about daily life, and what we call guardianship is substituted decision making. If you're the guardian, you are standing in the shoes of your child and making decisions for them. Now, of course, if your child is able, you're going to get their input, but guardianship, you're making those decisions. There is a legal trend away from guardianship because I served on the board of Disability Rights Texas for many years. I was the chair of that board, and they're an organization that's very much advocating for the rights of people with disabilities. They don't want their rights taken away by guardianship. There's a trend toward allowing an individual to retain their civil rights. So it's actually much harder to get a guardianship now than it was several years ago, especially with Texas. And you'll notice a reference to Down syndrome. I apologize for that. I gave this presentation to parents of children with Down syndrome, so I didn't change it. But just because your child is receiving special ed services does not mean necessarily that they need a guardianship. There are two types of guardianship in Texas. There's guardian of the person and guardian of the estate. So guardian of the person is going to be making medical decisions, making living arrangement decisions for that child. Guardian of the, so most of you, if you need a guardian, you're going to have a guardian of the person. Guardian of the estate is something completely different. Typically, when we think of estate, we think of what somebody owns when they die, but that's not the case in a guardianship. Guardian of the estate would be necessary if your child is either a minor or they're an adult that's incapacitated and they have their own money. So, for example, if they inherit money outright, or there's a personal injury settlement or something, then we might need a guardian of the estate. This allows somebody to handle the money and the assets of the child. Most of you will not need a guardian of the estate. Now, for guardianship of the estate, it's very complicated. It's very expensive. You have to report to the court about the money. You have to get permission from the court to use the money. It's quite complicated. Whereas if you're getting a guardian of the person, you don't have to report about money. You're just going to file an annual report every year talking about the condition of your child. Now, there is a partial guardianship and there's a total guardianship. A partial guardianship means that your child retains certain rights. So they might retain the right to vote, the right to drive, or the right to get married. So if your child is interested in politics and they want to retain that right to vote, then you can ask the court to allow them that right. The right to drive, they may or may not be able to get their driver's license, but if you think they might want that right, they can retain it, or the right to marry. A total guardianship takes away all rights. So there is the child retains none of their legal rights. Now, there is such a thing as a temporary guardianship, and these are very rare, but this is in a situation if you had needed immediate action to protect the child or their assets. So a temporary guardianship is for a limited period of time. And so these are pretty rare. Typically for our families where the kid's turning 18 with special needs, you don't need a temporary guardianship. So we've talked about what guardianship is. Let's now talk about the 8 steps to obtaining a guardianship. The first step is we have to decide and determine, is your child incapacitated? Because the court won't grant a guardianship unless the court finds your child incapacitated. So how do we prove that? Well, there is a certain form called a certificate of medical examination. You would take that form and your child to your child's doctor, and your child's doctor would complete that form. It asks a lot of questions, but that's the main way we prove incapacity. We have to show that your child does not have enough understanding to make responsible decisions. We have to show that your child cannot provide their own food and shelter. They cannot manage their own physical health. They cannot manage their own finances. So really, we're looking at whether your child has the capacity to make their decisions and provide for their own care. So a lot of it is decision-making ability on behalf of your child. So if your child has just a physical disability, but they're otherwise able to make decisions, you probably won't get a guardianship. Now, in some cases, we've had clients that the child is pretty high functioning, and they might want to have some other records to prove that their child is incapacitated. So they might need school evaluations or some other records to show that. Secondly, we have to show that the applicant is sufficiently qualified. So the applicant would be you, the person applying to the court for guardianship. Typically, it's going to be a parent, and if there's no parent, it would be next of kin. Typically, the guardian is going to be one guardian. Now, the court can appoint co-guardians in 2 situations. 1, if it's husband and wife, or 2, if it's both parents. Now, what do we do in situations where the parents are not married? Well, there are different scenarios. In some cases, both parents become co-guardians. So whenever that parent has custody of that child, then they are acting as the guardian and then the other one. In some situations, we might have the other parent who's not really a part of their lives, and that parent might sign a waiver. That waiver says, I don't want to be the guardian. I agree to the other parent being a guardian. So, we have parents all the time that are not married, and usually, every time we've handled it, it's worked out just fine. If the other parent, I've had a few where we couldn't find that other parent, and so we have to publish notice and try to serve them with notice and give them an opportunity to respond. And then if they don't, then they are not appointed as co-guardians. Now, if there are no family members available, then there are some other options as well. So we've determined that your child is incapacitated. We've determined that you are the proper applicant. And let me go back here. Proper applicant. Also, if you, as the proposed guardian, have been convicted of a felony or any kind of crime involving harm to a child, the court will not grant you a guardianship. So, so if you've got any kind of criminal record that might cause a problem, then you might want to see if there's somebody else who can be the child's guardian. In some cases, we've had situations where there has been a CPS investigation. It's really important that you tell your attorney about that and be upfront. Just because there's been a CPS investigation doesn't necessarily mean that you would not be appointed guardian. It really depends on the situation. So then we file an application for guardianship. This is what the attorney prepares. We file it with the court. Now, the attorney that you hire has to be someone who is certified to practice guardianship law in Texas. So not all attorneys, that you have to have the attorney has to have a special guardian ad litem certification. So make sure that the attorney you hire has that certification. Now, when you file the application, there will be court costs. And these are the costs that are the filing fee that the county charges. There's an attorney ad litem fee. There are a lot of different fees that are involved. So be aware of those court fees. Now, if you are indigent, if you are below the poverty level or near the poverty level, then we can file an affidavit showing that you're indigent. And if that's the case, then you don't have to pay those county filing fees. Now, you will have to pay the attorney that is representing you. So the attorney, like when I am hired, I represent the guardian, the parents. You pay their fee, and that fee depends on the county, depends on the attorneys. So for our firm, it's over $2,000. There are some attorneys that charge less. So if you are budget conscious, there are some other options there. So there's the filing fee, and then we'll talk about the attorney ad litem in a minute. And then the court will issue a citation, and the constable has to serve the papers on your child. So what that means is they have to physically take the certified copy to your house and hand them to your child. So there are a lot of protections in the guardianship laws. I think they were really enacted to protect like older people that somebody might be taking advantage of. So there are a lot of protections in the law that might seem a little crazy when you're the parent of the child, but those are the rules that we have to go by. And then there is a registration and training that you have to do online. And so your attorney would give you the link for that. The state will do a criminal background check based on your driver's license number. And then we have to do a registration. And then there's a training. It's a 1-hour online training. So if you're getting if you have two people applying for guardianship, you both have to do the training. Make sure when you get to the end that you complete it so that you get that certificate of completion, because we have to file that with the court before the court will grant the guardianship. The court is going to appoint a court investigator. So for the larger counties, there is a court investigators unit. And this court investigator typically will come to your home. Now, I don't know with COVID if they still come to your home or not. In Collin County, if you live in Collin County, they may or may not come to your home, but probably most of you live in Dallas County. Typically, this person would come to your home and they're going to interview you. They're going to talk to your child. Be aware that they're going to take your child to your child's room and talk to your child outside of your presence. So just be aware that that is normal. They're going to do that. This is not a CPS investigation. They're not looking for bad things, but they're going to look and make sure the house is decent, that there's not any obvious problem there. If you do have firearms, they're going to ask you about that. So make sure they are locked up somewhere I would make sure the firearms and the bullets are in completely different places locked up, and make sure there's no way that child could ever get to those. So be aware of that. That's an important thing in Texas. I've had some people tell me they think they can't get guardianship because they have firearms. No, that's not the case. You just have to make sure it's extremely safe and that there's no way your child would have access to those. The other thing that the court investigator is going to look at is to see, are there less restrictive alternatives available? So we're going to talk about that in a minute, because we talked about how guardianship takes away legal rights. So they've got to look and see, are there any alternatives to guardianship that would work and help your child that don't take away your child's rights? So they're going to be looking into that. And then the court investigator creates a report and files that court, and that goes to the judge. So that's part of what the judge uses to determine whether guardianship is appropriate. So if your child is high functioning and you're not sure they're going to get a guardianship, be aware that it's the court investigator that you're really trying to prove that your child's incapacitated. So if your child appears, like they might not need it, but they do, then make sure you bring all of that to the court investigator, because they report to the court. Because we've had some cases where the child appears to be high functioning, but there really are some serious reasons why the parents needed a guardianship. And so it was important for them to communicate that with the court investigator. You might even want to provide, again, school records or anything that might help to prove that your child needs a guardianship. Next, the court is going to appoint an attorney ad litem. This is an attorney that's going to represent your child. So the court has a list of attorney ad litems. Again, these are attorneys in the community that have completed the guardian ad litem training. So the court's just going to choose the next random one on the list, and then they are going to talk to you. So again, they might come to your house, and typically they will talk to you, talk to your child. And it's the same thing. If you believe guardianship's necessary for your child, you're going to be proving that to the attorney ad litem. If you've got any medical records or anything you want to provide them, you can. What they're looking for is, and this is true for the ad litem as well as the court investigator, they're looking at, is guardianship in the best interest of your child? And are there less restrictive alternatives available to help your child? So that's what they're going to be looking at. The next step is the court determines if your child, so we're going to have a court hearing. Who attends that court hearing? So that's going to be you, and if you've got a co-guardian, it would be them, your attorney, your child. It's really good if your child will be there, unless that would be bad for your child or they're not able to attend. The attorney ad litem will be there as well. And we're going to ask you questions to show that your child is incapacitated and that guardianship is in the best interest of the child. We'll show that the rights of the child are protected by appointing a guardian. We're going to show that you are qualified as the guardian. We've got to prove to the court that less restrictive alternatives are not sufficient to care for your child. If the court decides that guardianship is appropriate, the judge is going to sign the order granting guardianship. Now, again, it might be partial guardianship if your child has the capacity to do some of the tasks necessary, but not all of them. It's a partial guardianship if your child retains certain rights, but otherwise it's a full guardianship. And then the judge signs that order appointing you as a guardian. The next step is that you have to qualify as a guardian. So you have to sign an oath promising to be a good guardian, and you have to file a bond. So in Dallas County, I believe it's $100. That's a deposit you put in the registry of the court and you never get it back. But once you sign the oath and file the bond, then the clerk issues you a document called letters of guardianship. So the name of that's a little bit misleading. It's not letters. It's an actual, like a certificate. This is what shows that you are the guardian of your child and that you have the legal capacity to make decisions for your child. And so typically we'll get you at least a couple of those originals, and then you're going to want to make copies of that and then provide a copy of that to the school, to the medical providers, anybody that needs to see that you have authority to act on behalf of your child. I recommend that parents make a copy of it and keep it in their glove compartment of their car, so that if they need to prove it, they're out and about and they need to prove they have guardianship, they can do that. So now that you're guardian, what are your duties? So let's talk about guardian of the person, because that's typically what you will be. Of course, you're going to make sure your child's needs are met. You're going to determine where they live. You're going to provide their medical treatment. You'll decide where they go to work, where they go to school, who can be with them. Now, if it's a guardian of the estate, then you have to do a lot more. And we won't really go into it just because those are pretty rare. But what you cannot do, as a guardian, you do not have the right to place your child in a mental health facility. And we get this question all the time. Can I commit my child to a mental hospital? No, you cannot. There is a civil commitment process you can go through, but as a guardian, you don't have the right to do that. As a guardian, you do not have the right to force your child to take medication. That's not a right that goes along with guardianship. You are not legally responsible for their criminal activity. So some people don't want to be guardianship. They're afraid of that, but that's actually not true. But just remember that you don't get guardianship just to protect your child from bad choices. If it's going to be dangerous choices, maybe, but just because of bad choices, not so much. Also, you're not going to use your own assets to pay your child's debts. Now, each year you're going to renew the guardianship. So we talked about that document, letters of guardianship. That only lasts for a year. Now, actually, the first one you get is going to last 16 months, but after that, it's every 12 months. And then it expires. Now, we don't have to have a court hearing anymore. Typically, it's just that one court hearing. But there is an annual report that the court provides a form. You have to fill that out every year, send that to the court clerk, and then the clerk will issue you a new letters of guardianship. So every year you've got to do that. If you don't turn in that report, you might lose guardianship. So make sure you keep up with that. Now, the court investigator's office is supposed to come see you every few years. So they're pretty busy and they may not get to it. Typically, they're more worried about the contested guardianships. But at some point, you're going to get a call from the court investigator saying, hey, we want to come out. That doesn't mean you're in trouble. That does not mean that somebody has reported you for doing a bad job. It just means that your numbers come up. So let's talk about changes that can affect your guardianship. Guardianship can be modified by the court if your child's condition improves or if it gets worse. What if your child turns 30 or 40 and they don't need a guardianship anymore? They can actually apply to the court to have their rights restored and the guardianship terminated. So we have some parents, again, where their child's 18, they might be fairly high functioning. They can't take care of themselves right now, but the parents say, well, maybe our child could take care of themselves later. Well, that's fine. Maybe get guardianship now. And then when your child's older, if they don't need a guardianship, then that guardianship can be terminated. Now, what happens if the guardian dies or the guardian becomes incapacitated? In that situation, the court will appoint a new guardian. So when I'm doing estate planning for the parents and I'm doing a special needs trust, there's a document that I prepare for my clients in which my clients state who they want to be their child's guardian. So if both parents pass away, you get to have a legal document in writing that says who you want it to be, and the court will give great deference to that. If you move to another county, so guardianship has to be filed in the county where the child resides. So if your child moves to another county, it needs to be transferred. And that's pretty much an administrative type thing to get that transferred. If your child moves to another state, you need to have the guardianship transferred to that state. So you would have to hire a guardianship attorney in that state, and we would coordinate getting that transferred. Now, we've talked about less restrictive alternatives. Let's talk about what that is. The purpose of less restrictive alternatives is allow your child to be as independent and self-reliant as possible. So let's talk about alternatives to guardian of the person. The most common is powers of attorney. A medical power of attorney is a document that your child would sign that gives you authority, or whoever they name as their agent, authority to make medical decisions for them only if your child is not able to make your own. We would also do a Hipaa release, and you're all familiar with Hipaa, the Medical Privacy Act. We would do a Hipaa release that gives your child's medical providers permission to talk to you. So some people use this. We could also do what's called a durable power of attorney. This is a financial power of attorney that your child would sign. And this would give you authority to handle bank accounts, sign contracts for your child, and things like that. So these powers of attorney sound great. What could go wrong? Well, first of all, your child has to have the mental capacity to understand these documents. They don't have to be able to read every legal word, but they have to understand what rights they're giving and taking away. So, so they've got to have that mental capacity. The other issue is that a medical power of attorney, your child retains their legal rights. So they have their right to make medical decisions. So if their doctor says they need a surgery and your child says no, they're not going to have the surgery. Your child still has financial rights. So if your child gets a credit card, they're going to be liable. If your child signs a contract, they're going to be responsible for that. If your child opens bank accounts and things like that. So it provides no protections. So powers of attorney, no protections. Also, your child can revoke that power of attorney. So let's say that several years from now, they're living somewhere else and they've got a boyfriend or a girlfriend. They want to give that new boyfriend or girlfriend power of attorney. They can revoke the one they signed for you and give somebody else power of attorney. I have seen people, young people, taken advantage of by somebody coming in and say, hey, make me your power of attorney. So powers of attorney are not as protective. If your child needs protection, this may not be right for you. But we have a lot of cases where this is appropriate because the child maybe lives at home, they're pretty compliant, they've got the ability to understand it, and this is all they need. They just need a little help from their parents. So in some cases this works, in some cases it might not be appropriate. Now we've had a few clients who said, we're going to try powers of attorney, and then if it doesn't work, then we can apply for guardianship, because you do not have to apply for guardianship the day your child turns 18. So, and that, I'm going to deviate here for a minute. Let me go back and talk about guardianship. Typically, you cannot file for guardianship more than 6 months before your child's 18th birthday. So typically, you won't need to contact the attorney until a little bit more than 6 months before their birthday. So anyway, but if you don't do it 6 months before and they're already 18 or they're 21, it's okay to go back later. And you can show the court, we tried less restrictive alternatives and here's what happened. So that's perfectly fine. Now, the newest game in town is a supported decision-making agreement. And this is a law that Texas passed that allows you to sign a specific document. It's a written agreement where your child appoints you as a supporter. So do I have slides on this? I do. Okay, so we'll get to that in just a moment. Now let's move over to alternatives to guardian of the estate. What if, so what are alternatives? First of all, if your child is receiving SSI or is going to receive SSI, You do not have to get a guardianship of the estate in order to handle that Social Security check. You can be appointed as the representative payee. That is just a form filled out with the Social Security Administration that gives you authority to handle that SSI bank account. If your child inherits money outright, we might be able to do a special needs trust. So there are a lot of alternatives to guardianship. So if your child ends up with a lump sum of money, and as you probably know, they can't have more than $2,000 and be eligible for SSI Medicaid. So there are some trusts and things that we can do to help in that situation. Supported decision-making agreement. Your child signs this, giving you a supporter, and naming you as a supporter. As a supporter, you help your child analyze the options of a decision and help them make that decision, help them communicate that decision. There's a specific written form. It's got to be notarized or witnessed. Let me see if I've got a slide. I don't. So if you want to learn more about supported decision-making agreements, then I would recommend just Googling Disability Rights Texas and then supported decision-making agreement. They've got tremendous resources. They've got the form there. So that's a great way to learn about it.
Could you repeat that? Google what, Tressie?
Yes, Disability Rights Texas. That's the nonprofit. And then when you get to their website, you can search for supported decision making.
Thank you.
Or you can go to Google and do Disability Rights Texas supported decision making.
Thank you.
They've got great resources. So the advantages of a supported decision making agreement is that it doesn't take away your child's legal rights. Your child's in control of their decisions. So these agreements are not about control, but about support. So it's like, instead of standing in the shoes of your child, you're standing next to your child. The other great advantage is this is free. You do not need an attorney to do this. Now, some clients have come to me and we decide to do this, but you don't have to have an attorney if you think this is appropriate. So what are the disadvantages? Well, there's no court supervision. Somebody could maybe use that to take advantage of your child. But the problem, when this first came out, we thought this was great, terrific. The problem is you can't force anybody to honor this agreement. So you take it to school, they're going to know what it is. Schools are very much aware of this. So you provide it to the school and it'll work. But if you take a supported decision-making agreement to the bank and say, hey, we've got this agreement, I want to help my child with a bank account, the bank's never heard of it. You take the supported decision-making agreement to the doctor and say, hey, I'm going to help my child make medical decisions. They've never heard of it. So that's a problem. And it may not provide enough care and protection for your child. Now, in some cases, we do supported decision-making agreements and powers of attorney. So you can do both supported decision-making and powers of attorney. Now, you cannot do guardianship and powers of attorney, because if you get guardianship, your child does not have the legal capacity or the legal right to sign a power of attorney. But with supported decision-making, you can have both. And that's typically what we will do if the child has the mental capacity to sign those documents. So when I'm meeting with a family, I typically want them to bring their child in. And right now, of course, we're doing a lot of our meetings by Zoom. But when we talk about guardianship, here are some questions we talk about. Is guardianship going to be necessary to care and protect your child? Can your child make a decision that's in their best interest? Can they provide their own food and shelter? Would they be taken advantage of? And I will tell you, the possibility of them being taken advantage of is not the biggest reason to get a guardianship. If that's the only issue that you need to address, you may not get a guardianship, but that's just one factor. So can your child get medical care when they're sick? Can they communicate those medical needs with their physician? Can they understand the risks and benefits of a medical procedure? Can they sign an informed consent? Can they follow medical advice? can they handle money, their finances? Do they understand the value? And typically when a family comes in, I'm going to ask the child, you know, how much do you think this pen costs? You know, just to get an idea of what they think. How much does a car cost? How much do you think a house costs? And just to get an idea, if they even understand the value of money, because some people can make change. They've learned, you know, coins and things, but could they, if you gave them $100, could they go to the grocery store and figure out what they could buy for $100? Can they understand legal documents that would need to be signed? Can they advocate for their own education needs? Can they access the supports and services they need? Can they apply for SSI and Medicaid? Can they analyze and make decisions? And can they communicate those with third parties? So again, when we decide whether guardianship's appropriate, we look at, are there alternatives to meet their needs? And I like to look at it this way. Have I done everything possible to allow my child to maintain their independence and decision-making before I file for guardianship? So we really want to look at, is there anything we can do short of guardianship to take care of your child? Because really what we're trying to do is in your child's best interest. But you as the family have to make the decision. And I will tell you in some cases, if I think the court's going to grant a guardianship, because in some cases a child might be high functioning. And I can tell you, I don't think the judge is going to grant a guardianship in your case. You can file it, but I don't think they'll grant it. And in some cases, we simply don't know. And a lot of cases, it's pretty obvious. So my advice is to consult with an attorney in your family, in your county, to determine the best steps. So I don't know if there's anybody here in the outlying counties, but you want to make sure that you hire an attorney that practices law in your county, because these are all pretty county specific. So like, for example, my firm, we only work in Collin County, Dallas County, and Denton County. So if you live in Tarrant County or, you know, some other county, we typically won't take those cases. So, and our information is on the materials. So if you don't have an attorney and would like us to help you, feel free to give us a call, or any guardianship attorney in your area. So we do have some time for questions. Kara, are you good with answering questions?
I am, yes.
Okay.
Yes.
So we've got time. There's a chat box, but there's not that many of you. So if you wanted to unmute yourself, you're welcome to unmute and ask a question.
So can I start by asking my first question? Because I work with a lot of families that come, and this kind of decision between guardianship and an alternative often becomes about the finances that are required to get guardianship. So can you talk a little bit about the risks really between a supported decision making and a power of attorney? If you were working with a family who doesn't have the time or the resources to kind of investigate how to get guardianship for a student that may need it, is there one avenue that might be the first step to try in the interim?
Yes, and Kara, that's a good question. And honestly, I would not make based on finances alone. Guardianship's expensive. If you lived in the Houston area, it would be double what you're paying here because they charge at least $5,000. So let's look at the costs. But if you are a person that meets certain financial guidelines, you can go to the legal aid and they can file for guardianship for you. So there are some options, but their income limitations are pretty low. So that's difficult. What are the fees of guardianship? So you've got your own attorney's fees. You've got the filing fee of about $350. You have to pay the attorney ad litem fee, and that can be $500 to $1,000. And then whatever your attorney. So we charge typically at least $2,500. There are some attorneys that do that do more bulk guardianships that charge less. So so if you're budget conscious, that might be an option for you. But again, I wouldn't let finances be the sole determining factor, because if you really need a guardianship, you need it. I've had some people that even their church people help them to pay for it or whatever. But powers of attorney, are a much less expensive option, but they may not provide the protections you need. And so it would give you authority to handle finances, make medical decisions, but your child still has those rights. So if your child might be taken advantage of, it's not going to provide any protections. If your child, honestly, if your child is not compliant with you, and powers of attorney might not be good, because they might give powers of attorney to someone else, or they might, we had one case where the young man, there was a woman that he met online that was pretty good at taking advantage of people, and she wanted a relationship with him and take his SSI check and all of this stuff, and they didn't have guardianship, and the parents couldn't do anything. And so he was going to get married. He wanted a family, and she already had children, and it was a mess, just because there were no protections. And he, I don't know that he did, but he could have given her power of attorney. He could have done everything, because she can, convinced, she was persuasive. So powers of attorney don't provide protection. And so it really depends on your situation of your family. We've had plenty of families that don't need guardianship. And when I work with a family, I'll tell you what I think. I'll say, I don't think you need guardianship. You can get it, but I don't think you're going to need it. And again, you can always, if your child has the mental capacity to understand the powers of attorney, you can try that first. And then if it doesn't work 2 years later or whenever, then you can go to court and get a guardianship. You don't have to have it right when they turn 18. And the schools are great about working with you, because they've got, I guess, an education release, or you can have a supported decision making. So they're going to work with you. Now, I have had a few cases where the child is receiving medical services from Children's Hospital, and Children's Hospital said, we're not going to continue to provide services for your child unless you get guardianship. So in those situations, we had to get guardianship.
So I do have one more question, but I have a couple of questions in the chat box that I want to make sure we address, but can you not leave until I have my last question answered? So we have one question that said, what do you do about kids who don't want to work or go to school and don't want to live at home and want to backpack across the United States and live off the land?
Whoa, that's a hard one.
It is.
Yeah, it is. It's hard to protect them from bad decisions. But again, the guardianship's not to keep them from making stupid decisions. I don't know. I don't really have an answer. Maybe let them do it and see what happens.
Yeah, I think the deciding factor really is this a child who just wants to do what they want to do, or do you have very serious concerns about their safety at this time? And I think those are two different decisions. As a mom of a 19-year-old who allows me to experience the opportunity to make decisions I wouldn't have chosen for her, I have lots of experience with, but I think when we start to worry about our child's safety or vulnerability or the real issues that come around the safety of your child, that really is one of those times when you may want to consider guardianship. But again, guardianship really is more about a child who's incapacitated, not able to make those decisions independently, not a child who's choosing to make decisions that you don't agree with. And that's the fine line that really needs to be addressed.
Yeah, and the other issue is if you have a child that has a history of making dangerous decisions, then that helps you to get a guardianship. Just speculating about the future doesn't get you a guardianship. But if you have situations where, you know, the child keeps touching the stove, the child runs into traffic or whatever, I would start documenting those. If you think you need a guardianship and there's that history, that's definitely evidence of bad decision making. And I don't mean bad decision making, but dangerous decision making, decisions that would be adverse to your child's best interest or dangerous. Keep a record of those. And giving illustrations of real situations will help you prove that you need guardianship.
And then we have one more question, which is, can you explain a little bit more about not earning or having funds of $2,000 in your bank account regarding Medicaid?
Yeah, and so I would recommend that we do another workshop on special needs trust and government benefits, because for your child to get SSI and Medicaid when they turn 18, they cannot have more than $2,000 in countable resources. They cannot have monthly income of more than $2,000. If they have more than that, they will not qualify for SSI and Medicaid. So we have a presentation where we go over all of that, how to protect it. Now, the next one we have scheduled is on ABLE accounts and how to maximize your child's SSI check. We also talk about how much your child can earn and not lose those government benefits.
Yeah, so we did a training earlier in the year about Social Security and Medicaid, but I do think if we're continuing to have some of those conversations coming from our community, that it would be a great thing to repeat that. And so, Miguel, we may have another one we need to get on the books here pretty soon. So I appreciate your support in helping get that information.
And then I see another question. It says, if a grown child desires the parent's input, is HIPAA sufficient, or would you still need a medical power of attorney? I would do both, because a medical power of attorney lets you make decisions if they're not able to. So if your child is in it, and I do this for even young adults who are not incapacitated, is it lets you make medical decisions if they're unconscious or something, or they need a surgery. And so I would recommend both. You know, with my own daughter, I had her sign a medical power of attorney and a HIPAA so that if she's ever in the hospital, we've had situations where kids are off in college and they're in the hospital, and the doctors in hospital won't even talk to the parents, won't even let them know they're in the hospital. So good question.
So does anybody else have any other questions tonight? This presentation will be available to be viewed again if you need to go back over the information or want to look back at it. Certainly you can contact me, Kara Hayman, in the district at any time for additional information, or trustees available for consult if you choose to call and talk to her. I appreciate everybody's involvement tonight. Any last questions? I have my last question, Tressie, that I
think we've got one more too.
Oh, did we get another one?
Yes. So what is the average time frame from start to finish of this process?
What county are you in?
Well, I'm in Rockwall, but
Okay.
I'm a teacher in the program as well. So I don't have children. So
Right. So it depends on the county.
Oh, okay.
So Rockwall, Collin County, it's going to be a little bit quicker. Dallas, at least 6 months. The problem is there's two holdups. One is that state background check and stuff, it takes them a while. But Dallas is really backed up right now. And they got backed up from COVID. So just getting a court hearing sometimes can take us a few months. So we've had some lately that took 9 months. But in Collin County, we get pretty quickly. Rockwall is pretty quick as well.
So Trustee, I have a question, and I want to ask this in a professional manner, but we serve a lot of students who aren't necessarily in the state of Texas legally. Are they able to apply for guardianship if they have a child who requires that level of service?
Yeah, and so that's a good question, because I had this case come up. Yeah, that state background check, they just started that a few years ago, and I had a client in that situation, and I talked to judges, I talked to people. I said, I need to make sure that this mom, nothing's going to happen to her, you know, if she needs to file for guardianship. So nobody could promise me nothing happened, but I will tell you that nothing happened. So yes, we've had parents that were not, did not have legal status, who were able to get guardianship, and there were no negative consequences. I cannot guarantee that.
Okay.
In that one case, she had to have guardianship because it was one of those where Children's Hospital was going to stop serving, and nothing happened. So again, when I talk to
that, for our families who are super concerned about that, they could have a supported decision-making agreement.
They could, but if they really need guardianship, I would do it. And then if something happens to their if that causes a problem with their immigration status, I think there would need to be some lawsuits, because I think everybody agrees that shouldn't affect somebody's ability to get guardianship, because we're trying to protect this child and take care of the child. So I think it would be illegal for the state to do that, but I can't guarantee it. But I would just tell you that in the cases we've had, nobody has had an immigration problem to date, but this is Texas and we don't know.
Yeah, that's a good answer. And then does anybody else have any questions pertaining to guardianship or?
I just wanted to add a comment. And so Tressie, regarding, immigration status and all those are very, very sensitive issues. So I think, we're not providing any kind of legal advice, of course. I think if families listen to this, what they need to know is that, before making any decisions, they need to contact probably someone who's familiar with the laws and what can be done. So, because that's a scary thing, especially when you're trying to help your child. So,
yeah, that's a good point. We did have one case where the family chose a family friend to be the guardian, because none of the family members had legal status, and that was just their choice. But some cases, the parents are the only ones that can be the guardian. And so I think we have to weigh the risk. Is it worth it? And in that one case I had, it was absolutely worth it, because this child had to have medical care.
Yeah, so Miguel, thank you. I think this session is not to provide legal advice to families who are in this situation, and we encourage you to seek legal counsel or some other avenue to get that information. But we did want you to know, we want you to hear that there may be some options that could be considered for families who are really, really in need of getting some help with guardianship issues. So thank you for that clarification.
Yeah, a good point.
Okay, well, Trustee, we really thank you for taking the time and coming and helping us. I know our group was small today, but this for all of us is being recorded will be available on the website through Parent University. So if you have a friend or you have another parent that would need some information, going on to the RISD website under Parent University, they'll be able to access this training in both English and Spanish. And so we can send links directly to families who might need this information.
Kara, if I may,
Sure.
I do webinars like this every month. If you go to my website, weekslawfirm.com, at the bottom, you can actually register. I have one, I think this Thursday, on special needs trusts. So I do that every month. It's free. You just have to sign up for it because I have to send you the Zoom link. So if anybody wants to attend that, you're welcome to. Again, there's no, it's just a free webinar for you.
That's great. Thank you. I didn't realize you were doing that, and we can certainly.
I'll put the there. I just put the website in there.
Okay. And we'll get that out to families who in the interim need. I think that's one of those issues that we have a lot of requests for information about.
Okay. Kara, thank you so much for the opportunity.
Sure.
And I appreciate all of you guys attending tonight.
Thank you. Miguel, do you have anything you want to end with?
Well, I want to thank Tress. I want to thank you, Kara, for providing this information to our families. One thing I didn't do is introduce myself. I'm Miguel Benitez, and I'm the Director of Family Engagement. I get these sessions going, and it just want to get information out to our families. So we really do appreciate you taking the time to access any of our sessions, Parent University sessions. You can go to our website at www.risd.org/Parent Corner. It'll take you right to the parent resource page, if you will, and you should be able to hit the Parent University video library. It'll open it up and just scroll down. You'll see all the videos that we've recorded for our families. So again, I want to thank you for taking the time to attend and to listen to this wonderful presentation. And so I want to thank y'all again for taking again the time to be with us. So sometimes I say that a lot because I really do mean that. I mean, we live hectic and busy lives, and so we do appreciate you.
We appreciate the partnership, Miguel, in trying to get information out to families and making it accessible for families who aren't able to join us tonight. So thank you, everybody. And I hope that we will see you all in a couple of weeks on the 27th for another one of Tressy's presentations. So we'll see you then. Thank you.
Thank you. Bye-bye.
Bye-bye.